Hello there, and welcome once again, Disability Law Show. I'm John Scholes. With me, of course, James Fireman, Sivan Tumarkin, all that from Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. Reach out anytime you want. Have that chat, 1-855-821-5900. help@disabilityrights.ca. A couple more websites we'll mention throughout the half hour as well that you can use freely and anonymously. On the show today, guys, 3 ways applying for CPP disability can help your LTD claim. That's in just a little bit, and some emails that we're going to get to as well, but we always start off with the week that was. Sivan, what do you got, pal?
Well, John, it's great to be here with you, with James. Let me tell you, generally when we talk about the week that was, I mention an interesting phone call, a conversation, an email that just came through. But I have something a bit different. My wife and I visited a friend of ours who is a psychologist. We went to their home for lunch on a Sunday, and we were talking about long-term disability and what she sees in her practice. And she mentioned a few things which I thought were quite interesting. Nothing earth-shattering for us. We hear this a lot, but it was interesting to hear it from her directly. Number one, that she has seen a tremendous spike post-COVID of people with tremendous anxiety that is disabling them from working. Anxiety, depression, even PTSD, depending on the situations that they were in and what happened to them and their families during COVID, before COVID, after COVID. And so we were chatting about what happens with long-term disability and how her patients navigate long-term disability applications and denials. And what was interesting to me is when I was explaining to her the test for long-term disability, being that you cannot perform the essential tasks of your own occupation, it took her by surprise because she was focusing on the verbiage that we often see people come to us with, which is, am I totally disabled? That's the test. You have to be totally disabled. And we see this all the time. And this one word, total, totally, total, people understand that word to mean completely disabled, catatonic. You know, you can't get out of bed, brain injury, something like that. And it's nothing of the sort. Now, we've said before, in our opinion, in my opinion, I won't speak for James, I think it's an invented term by the insurance industry to confuse people and to confuse practitioners, psychologists, doctors, anyone else that is helping individuals apply for long-term disability and supporting them being off work.
You can speak for me.
Okay, I'll speak for you as well. You know what? We have seen, there's no other reason, there's nothing else that we can think of as to why an insurance company created this term, which is very misleading, total disability, making people think that, you know, unless they're completely and utterly, you know, confined to their bed or their house, they cannot get long-term disability, and that's not true. All you have to show in order to get long-term disability is that you are unable to perform the essential tasks of your own occupation. If you're beyond the 2-year mark, the test changes a bit, but the point is, you know, I'll give you a very simple example here. Let's say, John, that you are a surgeon. Let's say you're a doctor, right? And you hurt your little pinky finger, and because of that, you can't perform surgery. You are totally disabled under the policy that you may have for your own occupation. You may be able to teach, you may be able to supervise, but you cannot actually perform the essential tasks of surgery. And so just with that little thing, you are now totally disabled. You're not catatonic, you're not brain dead, nothing of the sort. So we had this conversation and I was explaining to her that we help people all the time get those benefits that they are denied incorrectly, unjustly, and frankly, illegally by insurance companies. But what's more concerning to us is that people sometimes don't even apply because they think that they will not get those benefits. And so we're here to tell you, I'm here to tell you, the lesson here is, if you are unable to work because of any condition, any illness, any injury, and you have a long-term disability policy, please apply. And if you get denied for any reason, reach out to us. It doesn't cost anything for us to take a look at the denial, the documentation, and to give you our advice for free if the insurance company is correct or not in its denial.
What's your take, James?
Well, I want to actually back up to the start of what you were talking about, and that you're speaking with the psychologist who's talking about this wave of mental health conditions. And that's something that we saw coming. This is when the pandemic started, and when we realized that this was going to be something that was widespread, that was going to have an enormous impact on everyone. There were stories all over talking about what was coming from a mental health perspective. And they were absolutely right. We are absolutely seeing that, and it is an enormous problem, not just because it's creating mental health issues, but because we have a lack of mental health care. We have a lack of primary health care and mental health care all across this country. From what I've seen, it is considerably worse when you move out of city centers as well, too. And that creates a very specific problem for people who are trying to access disability benefits, because you are required to show that you do have a condition that's preventing you from being able to do your occupation. And if you don't have access to primary care and mental health care, it's difficult to do. What can you do if you're in that situation? You have to do everything you reasonably can. If there is no access, then you have to find some other way. So from a primary perspective, we're talking walk-in clinics. And for some people, that might mean driving several towns over if you're particularly rural. But without that, without showing that you have been seeking medical care for a condition, it's going to be impossible. And what about for mental health? Well, for mental health, we hear all the time that people get referrals for psychiatry and it takes 6 months, a year, 2 years before they actually can even be seen, depending on where they are. That's commonplace now. But in the interim, that doesn't mean that you can't get any mental health care. You certainly can get a referral from your doctor to see a psychotherapist, a counselor, even a social worker can provide therapy services. There are free resources if you don't have extended health benefits that will cover it. There are online resources you can use, which can be especially helpful if you don't have somebody local. It isn't perfect. This isn't necessarily going to solve all your problems or address your problems in an ideal way, but it's a start. It is better than nothing. And if you are taking those steps to show that you are doing everything that you can to address the issues you have, but it's not perfect because there is a lack of mental health care, then at the very least the insurer can't say that you aren't doing whatever is possible. So it is critical that you take those first steps, you get the ball rolling, and that when you are able to get that care, you go ahead and you follow through on all the recommendations.
How do you guys find insurance companies are dealing with the post-COVID, with a lot of the claims? They digging their heels in and still denying? Because it's going to be an onslaught for them, I would imagine.
It's really interesting the way we see the divide between the claims department and the legal department, and it is very, very different. In the claims department, if there is a hint of long COVID on your application, almost always you're going to find the insurer is going to deny the claim during adjudication. Not 100% of the time. If there is another disability that would justify it very clearly, then perhaps in those circumstances. But generally speaking, if you have a long COVID type of disability, we see insurers almost across the board deny those claims at the adjudication claims level. But then as soon as we bring a claim, all of a sudden they come to the table and they're very motivated to pay. And the reason is very simple. There are no reported cases where a judge has made a decision on a long COVID disability.
Wow, okay.
And as soon as there is, if there are benefits awarded, there is going to be a flood of applications for people that have long COVID and have access to disability benefits. So what do the insurers do? At the claims level, they deny everything because they don't want to encourage people to apply if they have long COVID. They don't want people thinking, oh, you have long COVID, well, you should get your disability benefits. They want to create the exact opposite impression. But as soon as you bring a lawsuit, as soon as you bring a legal claim challenging that, they can't afford to have that reach a judge. They can't have a judge make a decision on that. So they're very motivated to resolve the legal claims where people are challenging denial of benefits for people with long COVID.
Is it just a monetary thing they don't want to reach a judge, or it gets out in public?
It's absolutely. So as soon as there is a reported decision by a judge,
right,
it is freely accessible by anyone. Anyone across the country. And the moment that happens, I promise you, every news outlet in the country is going to pick up that story. And that is going to be enormous. That's obviously something that every insurer has a very strong interest in avoiding because it's bad for all of them. Right. It means all of them are going to be paying out a lot more in benefits than they would like to.
There's an app called pocketemploymentlawyer.ca. It's usually for the Employment Law Show, but we do that, we use it, in fact, we talk about it here on this show, pocketemploymentlawyer.ca. Sivan, tell me why you like it so much.
Well, you're right, John. I mean, we have employment lawyers at the firm that help people who've been let go from their jobs, who are having issues with their employers. At the same time, obviously, a lot of these individuals who are having difficulty at work have those difficulties because of disabilities. And so many of them also have at the same time issues with their long-term disability insurance companies. And so people come to us because they have both issues with the insurance company and with the employer. And so we've created this website, the Pocket Employment website, because people can then get free, quick, and accurate answers to their questions, not only on the employment side of things, but on the long-term disability side of things as well. Sometimes people don't want to call us. They don't want to necessarily email us. They don't want to communicate with a lawyer for any number of reasons, even though it's absolutely free to speak with us about long-term disability. They would rather just go to a website. Well, I'll tell you this. Do not Google these questions because you're going to get misinformation. And in fact, much of the information you're going to have coming up will come from the states where the laws are completely different or other provinces. So go to this Pocket Employment Lawyer website. You're going to give the website again, John. And again, it is accurate, it is free, it is quick, it's customized, and it's anonymous. Now, if you want to get in touch with us after you get your answers, by all means, you can click the button. Otherwise, you can very simply just close the browser and we will not know that you were there.
Again, guys, pocketemploymentlawyer.ca is how you access that. Let's get to an email here while we get into a break here in a few moments, but it's Carmela this time around. First one off says, my brother has been suffering from depression for years. His condition has worsened to the point where he isn't able to function at all and is now on medical leave from work. His psychiatrist recommended he apply for LTD, but the insurance company denied his claim. He wants to appeal, but I think he should explore all options. First, what should I tell him?
Well, you should tell him that I've written into my contract a clause that requires any questions that have the word appeal to be directed towards me. So let me answer your question, Carmela. First of all, thank you very much for reaching out on behalf of your brother. I think it's really important, especially when we're talking about loved ones and friends that have mental health issues. It can be really difficult for people in that position to get the ball rolling, to get information, and to challenge insurance companies when they're taking positions that you understand to be wrong. So I really appreciate that Carmela is doing that on behalf of her brother. The answer is very simple. Don't appeal. An appeal is not just a waste of time, but it is actually playing into what the insurance company wants. When you bring a claim and the insurance company is adjudicating that claim, there's nobody looking over their shoulder. There's nobody making sure that they're doing so fairly. And they have very little motivation to do so fairly. Absent a case where your application is very clearly a disability and one where they really just can't even skim the surface of a justification for denial, unless you have that type of situation where it's just obvious they're going to deny your claim. And we see that all the time. And there's really nothing to motivate them not to do that. Now, if you appeal, you're still in their sphere. There is still nobody looking over their shoulder. There's nobody who is making sure that they are interpreting the policy in a fair way, the way that the law has interpreted it. And so if you do that, you're going to get the same result. Once they found a justification to terminate your benefits, they're not going to all of a sudden change their mind. They are a corporation. They are there to make money for their shareholders. And so that's what their motivation is. That's how they make money, by denying claims. Once they have found that justification, you're not going to knock them off unless you give them some information that is completely different than what they already understand. If all of a sudden now you have a cancer diagnosis that explains things in a way that they didn't before, then maybe, I'm not even going to tell you then for sure, but maybe then it's worth appealing. But if you're giving them the same information, you're not going to get anywhere. Even if it's with a letter from your doctor imploring them to just listen, like, my patient is absolutely disabled. There's no way they can go to work. Just look at the documentation. I've seen letters from physicians, well-meaning physicians, many, many times where someone has appealed before they've come to us, where a doctor has written that kind of letter and it goes nowhere. It just goes nowhere because they have no incentive to listen, to change their mind. The only way to get them to take your case seriously, the only way to get them to act reasonably and to do what they're supposed to do, is by bringing a legal claim. And the reason that's effective is because they know that if they are not reasonable during the legal claim, then at the end of the day, they're going to have to go in front of a judge and explain themselves. And that is a very serious threat. As we've already talked about, if a judge has to make a decision, it becomes public. And if a judge is talking about all of the ways that they have not acted in good faith, that's going to be really embarrassing for them, and they don't want that. As soon as you bring a legal claim, all of a sudden they're acting reasonably. very long-winded way, Carmela, of saying don't appeal. It is going to be a waste of your brother's time. Give us a call. We can absolutely help your brother and make sure we bring a legal claim and get it resolved as soon as possible so that your brother gets the benefits he's entitled to.
And with that, we'll take our first break and get right back into it. Why you should apply for CPP disability. We'll cover that on the other side. In the meantime, that number that James just mentioned, 1-855-821-5900, help@disabilityrights.ca. We'll continue. More disability law shows on the way. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show. John Scholes here, and with me, of course, James Fireman and Sivan Tumarkin as well. Reaching out anytime, 1-855-821-5900, help@disabilityrights.ca, or simply disabilityrights.ca, the firm website. Okay, we mentioned 3 ways applying for CPP disability can help your LTD claim. I'll throw the first one to you, Sivan. An approval for CPP disability can strengthen your own LTD claim as the test to qualify is more difficult, right?
Yes, and you know, there can be an argument over that. More difficult, less difficult, the same. It's certainly not less difficult than getting qualified for long-term disability, and arguably even more difficult. You have to show that your illness or your disability, rather, is serious and prolonged. And you're dealing with the government. It's the federal government. And we've helped our own clients who are on LTD get CPP disability successfully. And the reality is that once the government deems you disabled, for the purposes of CPP disability, the insurance company has a lot more difficulty arguing that you are not disabled. Now, they may try and cut you off for other reasons, and they do sometimes, but it makes it that much harder for them. And so if you are applying for CPP disability, and we can get into the merits as to why you should or should not apply, pros and cons, we think there are more pros than cons. The reality is if you do get CPP disability approval, that is going to strengthen your claim as it relates to your long-term disability insurance company.
Number 2, James, this one's for you. In the event of being cut off from your LTD by your insurer, you'll still have a source of income to pursue a legal claim.
Yeah, that's a question that we get all the time. People are obviously, for good reason, concerned about what's going to happen while they're not getting disability benefits and they're not working, and we're trying to get through their legal claim. You know, the timeline is typically around 10 months, which is, by litigation standards, lightning fast. But that's still a long period of time for people to be going without disability benefits or income. So what can you do in the interim? Well, number 1, apply for CPP disability. The limits for the monthly benefit go up each year, and if I'm not mistaken, I think they're just a shade under 50. I think they're actually closer to $1,500 now. They go up at the beginning of each year. So I think it's around $1,500 a month. Now, typically that's going to be an offset against what you're ultimately entitled to down the road. But if you're not earning any money and you're not getting any benefits, you'd so much prefer to get that money up front and then have to, deduct it from what you're entitled to down the road. So be it. So that is definitely a huge advantage for applying for CPP disability if you're approved. There's also the EI sick leave benefits as well, and for Ontario, Alberta, and BC, I believe each of them has a provincial benefit for disabled persons. The test for the provincial benefits is usually more difficult. It usually involves looking at your assets, but it's worth applying because it is an issue for all of our clients. They want to know how they're going to be able to pay their bills while they're waiting, and this is definitely one big part of that.
Talking about how CPP disability can help your LTD claim. Point number 3, Sivan, by applying, and you touched on this for CPP, you're giving your LTD insurer one less reason to cut you off your benefits or reduce that monthly payment.
Yeah, I mean, we get a lot of emails, calls as well from people who say, listen, why do I need to apply for CPP disability? The insurance company says I have to, but why do I have to? And the reality is this, that the insurance company wants you to apply because if you get approved, while it makes their life more difficult in cutting you off because of an argument that you're not disabled, because you have been approved, they get a benefit. In other words, if you get approved for CPP disability, you're not getting that amount on top of your LTD amount. It's just that your insurance company gets a credit for whatever amount you're getting from CPP disability. Simple example. Let's say you get $3,000 a month from your LTD insurer. You get approved for CPP disability at $1,500 a month. You're not getting $1,500 plus $3,000. You're still getting $3,000, except that the insurance company only pays you $1,500, right? Because they get a credit for CPP disability. But if you don't apply when they tell you to, the reality is that the insurance company is most likely going to guesstimate what they think you ought to be receiving and then unilaterally reduce your monthly LTD amount by that amount. Now, in some more extreme circumstances, they will say that you are in breach of the policy. If the policy contains a provision that says that you must apply for CPP disability and you say no, they may say, well, no, you're breaching the policy by not applying. We're going to just stop your benefits altogether. More rare, but it does happen. So the reality is by applying for CPP disability, not only, as James said, you're getting an extra source of income in the event that you get cut off LTD, and you're making the insurance company's life more difficult because the government recognizes you as being disabled. But in addition to that, the insurance company has, again, one less argument for you being in non-compliance with the policy and also for not reducing your LTD amount arbitrarily without you getting anything from the government.
You know, I understand why people are hesitant to do it because they're asking, well, why do I have to do this? Does it say in my policy that I have to? And people don't like to do things that insurance company tell them to do when they don't actually have to. And I appreciate that instinct, believe me, I do. But what I'll say is, in the end, I have to say it's probably in your best interest to do it. Even though ultimately it is helping out the insurance company, it is also in your best interest, so you might as well.
And with that, we'll take a short break. There's a website called mydisabilityquestions.com. It's free, it's anonymous, you can ask questions there. It's got a searchable database. We'll talk about that in a bit. And we'll get to a question from it upon a return. In the meantime, that number again, 1-855-821-5900 and help@disabilityrights.ca. We'll continue with more of the Disability Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. This is the Disability Law Show. We mentioned just prior to the break a website called mydisabilityquestions.com that was created anonymously and freely for you to use. The beauty of it is you can ask your questions there, use your phone, your tablet, your desktop, whatever. Sivan and James and their teams get to those questions pretty quickly with an answer. You can also search for your questions, see if one similar has been asked in the past. That is the way the algorithm works. So it'll save you some time. In any regard, Mateo, guys, is up first. He says, the insurance company recently referred me to a rehab consultant for my disorder. Without my doctor's knowledge, I've been put on a return to work plan. This new program has aggravated a lot of my symptoms, and I feel my stress levels have increased. Am I permitted to opt out of this?
Well, I'd be careful about using that language, opt out. It's not really the way that it works. Your insurer is entitled to have their view of what you're required to do in order to get back to work. They have to medically support that. But that doesn't mean that as soon as they tell you that this is what you should be doing, that you should just instantly jump to doing that. Before you agree to any return to work program or any type of therapy or treatment that the insurance company says is necessary, the very first thing you do is you say, I need to run this by my doctor first. Not after you've started, but first. You want to have your doctor review the entire program. If it is going to be a return to work plan, so what types of medical professionals are you going to be seeing? How long will the program run for? How many times a week are you going to be doing this? What different types of activities are you going to be engaged in? And what is the objective of the program? Have your doctor review that. And if your doctor agrees that it's appropriate and that it's not going to set back your treatment and that it might even get you closer to the place where you need to be, great.
Better.
But if your doctor has concerns, if your doctor thinks that it's not appropriate given where you are in your recovery, that this is actually going to set you back or at the very least isn't going to be helpful for you, then make sure your doctor not only reviews that, but puts their opinion in writing and provides that to the insurance company so that the insurance company can reconsider whether it's worthwhile. Now, if your insurance company at that point, after getting your doctor's letter that says that it's not appropriate for you to participate in the return to work plan or whatever the treatment is, and they still say, no, we still say you have to do this, and if you don't, we're going to cut you off, then you have a decision to make. My advice is always that you should listen to your doctor. This is a medical decision. Whether you undergo particular treatment is a medical decision, and you should be taking medical advice from your doctor, not your insurance company. Having said that, I appreciate that people are living in a world where they need to continue their benefits as long as possible. And if you don't do that, despite the fact that your insurance company is telling you they're going to cut off your benefits, then you are risking your insurance company cutting them off. Now, if they do that with a letter from your doctor, then we can absolutely bring a claim to challenge the denial, and it should be successful. But I appreciate that people have to decide what they're going to do when it could impact their benefits, when it could mean that their benefits are going to end earlier. That's not really a legal question. That's much more a question of their own particular realities. But again, my advice is always to go to your doctor first and listen to what your doctor is saying. In Mateo's case, what can you do here? Well, he's already started it, which is unfortunate, but he should be reporting the issues he's having to his doctor, and now his doctor can, with that information, write a letter talking about the impact this program is having on his situation and provide that to the insurer, and presumably with a recommendation that the program be stopped immediately because it's having a negative impact. And again, if the insurer doesn't agree with that, then Mateo's going to have a choice to make whether he wants to continue, despite the fact that it's aggravating his condition, or listen to his doctor and risk the insurer cutting it off and start a legal claim, which will be in a much better position to be successful once you have that letter.
It's a stressful thing, Sivan. What do you think? Like, return to work program, the doctor doesn't know about this?
Very, very stressful. Very inappropriate in my view that this was not coordinated with the doctor. I agree with everything that James said. I think one of the things that we stress for people is because it doesn't cost anything to speak with us, why not just throw those questions at us before you actually do something like this? And so when we speak here and we do this show and the radio shows, we tell people it may not be applicable to you, but you may have a relative or a colleague or a friend that is going through this. They should not be walking into any scenario or situation blindly, especially when you're dealing with insurance companies, because there is an imbalance of power and knowledge. The whole point of this show and other shows is to teach people what their rights are and what they can do. And so again, to reiterate what James said, it comes down to what your doctors are saying. But if at any point you have a question, if at any point even the doctor has a question, they can always reach out to us. We're more than happy to speak with the doctors, with psychologists, with anyone out there who needs information on how to navigate these issues.
And refer to the policy, right, James?
Yeah.
Like, always look at your policy first, right?
100%. And if you don't have a copy of the policy, ask for a copy from your insurer. And if they give you the runaround, you can probably get it from the HR department from your employer.
And that is just about it for another show. Appreciate you tuning in and contributing. If you sent an email or went to mydisabilityquestions.com, you can always use that now that we're done with the show. Email one more time, help@disabilityrights.ca. You can use that anytime you would like. And as Sivan said, always start with that phone call, have that chat, get some satisfaction, some education at the same time. 1-855-821-5900. And we'll catch you on the next episode of the Disability Law Show. Thank you.